You're moving in together. It sounds like the perfect solution. You save on expenses, the grandkids are right there, and you're there to help as your parents age. But in 2026, I am seeing more families fall into a legal trap that can cost them thousands in taxes and tears, and families can fall apart over inheritance. And today we're doing a deep dive into multi-generational buying. We're talking about why right of survivorship might be a massive mistake, how to use a HELOC to fund in-home care without draining your savings, and how to make sure the siblings who don't live in the house don't get cheated out of their inheritance. These are things that I talk about with clients every day. I'm not a lawyer, and you're gonna need one, but I'm gonna tell you exactly what questions to ask them. The biggest mistake I see, people say, let's just put my adult child on the deed with right of survivorship. That's easy, right? When the parent passes, the child owns the house. Done. Stop. Here's the reality. First, capital gains. If you gift half the house to your child now by putting them on the deed, they lose the stepped up basis on that half. If that house appreciates, they could owe the IRS a fortune when they sell. And also creditors. If your adult child gets into a car accident, a messy divorce, or a business failure, your home is now an asset to their creditors. Creditors can come after your home and your assets. So talk to an estate attorney about a revocable living trust. You can title the home in the trust. This keeps the home out of probate, protects the tax basis, and keeps the house safe from any personal legal issues that your child may have. Now let's talk about the other kids. You know, you have one child living in the house caring for you, but you have two other children maybe living across the country. How do you stay fair? This is where people get stuck. If the house goes to the child living there, the other two feel disinherited. But if you force a sale immediately after the parent passes, the caregiver child could be homeless. Let's talk about the 5-year exit strategy. I've seen attorneys draft trusts where the live-in child has the right to reside in the home for, say, 5 years after the parent passes. During that time, they pay for the upkeep, and after 5 years, the house is sold, the proceeds are split among all the children. Or the live-in child has the first right of refusal to buy out their siblings at a predetermined price. This gives them stability while ensuring that the inheritance is shared and nobody's disinherited. Let's talk money. As a senior ages, the home needs to change. We're talking ramps, widening doorways, or maybe even a walk-in tub. And right now, with home equity at record highs, a HELOC, home equity line of credit, is your best friend. But it's tricky with co-owners. If both parent and child are on the title, both generally need to apply for that HELOC. The HELOC is a powerful tool because one reason is accessibility. The interest may be tax deductible if the modifications are for medical necessity. You need to check with your CPA, of course. Care funding. You can draw on that HELOC to pay for in-home nursing care. This keeps the senior in the home longer and prevents like a fire sale of the property to pay for a nursing home. And here's a pro tip, set up the HELOC before the senior needs care. It's much harder to get a loan approved if the primary income earner is no longer medically or financially fit to sign. Specifically for my viewers here in Georgia, there are programs you need to know about that most people miss. If you're trying to provide in-home care, look into the Elderly and Disabled Waiver Program, EDWP, which includes what we used to call CCSP and SOURCE. And in 2026, the income limits have shifted. So if the senior makes less than roughly $2,800 a month and has limited assets, not counting the home they live in, Georgia may actually pay for personal care assistance, meal delivery, and even respite care to give the adult child a break. The catch is that Georgia has estate recovery. If the state pays for care, they may try to recoup that from the home's value after the senior passes. This is why the trust we talked about earlier is so vital. You need an elder law attorney to shield the home from recovery while still qualifying for the help you need. Multi-generational housing is a beautiful way to live, but it does require some planning so that everybody feels comfortable. So you have 3 steps of homework from me. Don't deed. Call an estate attorney and ask about a living trust versus joint tenancy. Define the exit. Decide now in writing how long the adult child can stay in the house after you're gone. Audit the equity. Look at a HELOC now while everyone's credit and health are stable. If you found this deep dive helpful, hit that subscribe button. I've put a link in the description to the Georgia Division of Aging Services so you can check those care funding limits yourself. Would you like me to do a follow-up video on the specific tax implications of the 2026 gift tax limits? Let me know in the comments. If you need me to go a little deeper into any of these topics we've talked about today, I'm happy to do that as well. I'm Amy Parris Cook, your North Georgia Realtor. I've put together a multi-generational housing checklist questionnaire for you. If you would like to get a copy of it, just comment downsize below and I'd be happy to be in touch.